Good morning, everybody. Welcome. Just a heads up, for some reason, which may be my fault, because who knows, the Q&A, the Q&A box, it doesn't really work. So attendees can't see what questions are being asked. So you can ask the questions in the chat. And I think that that works great. Okay. And I think that's something that we can easily monitor, and it makes for everything a lot easier in terms of asking questions and having information out there. Welcome. This is our second session of Stream 4. We have a great group of panelists here, and I'm looking forward to another of ASC's DCS student spotlights. And I am fine if you want to go in the order that the program suggests. So I don't want to butcher your name. Is it Ciara?
It's Ciara. It's
Ciara. Okay, name. Great. See, I mean, that's why I was like, I don't want to butcher it. So, okay. So Ciara?
Ciara, yeah.
Ciara. Okay, perfect. Ciara. All right. So Ciara, if you want to go first, we should be fine. I'm going to give you all of you about 11 minutes. I know it says 10, but we have 3 presentations, so I think we can increase the time a little bit. When you've reached the 10-minute mark, I will just come on and just say you have 1 more minute. Okay.
Perfect.
You can share your screen, and I am going to stop my video, and I am going to mute and take it away. Good luck.
All right. Should I turn on my video for these?
Depends on what you want to do. You can share your screen if you have a PowerPoint. You can turn on your video if you want to, if you have a different mechanism for presenting. It's up to you. You have full control.
Perfect. I just have a PowerPoint, so I'll just share that. All right. Well, my name's Ciara McGlynn. Today I'm going to be presenting work I did for my master's thesis at Portland State University, looking at identifying typologies of defendants who fail to appear to their court appearances. So pretrial practices are a growing area of interest, given that pretrial detention makes up over 60% of the average jail population, and $13.6 billion is spent annually on it. Court appearances are an important area of focus, as when an individual fails to appear, it can cause court delays and the individual can receive sanctions. The goal of this study is to identify factors indicative of failure to appear that can be used to target individuals and increase their court appearances. So there's a growing body of literature that attempts to predict outcomes related to pretrial release. There's some mixed findings regarding gender, race, and age, but the majority of studies do find that they are predictive of failure to appear. Males are less likely to fail to appear if they're married as well. And being in on a property or drug offense or felony charge and having a criminal history are predictors of failure to appear as well. Typological research, which is also known as classification, is a growing area of criminal justice research due to its ability to hone resources and efforts towards specific individuals. Machine learning is how typological research is conducted. So there's supervised learning, which is able to identify cases that go into pre-existing classifications, and unsupervised learning uses analysis to discover and identify characteristics for categories, which creates new classifications. Examples of this are cluster analysis, which has been used previously to create profiles of juvenile offenders, and latent class analysis, which has been used in Washington State to create typologies for a risk needs tool. So there's a number of gaps in the literature that this study seeks to fill. Prior research involving failure to appear includes usually only static variables and focuses on predictability of factors. Static factors don't tell us much about the individual, as these are things we already know. So it's important to examine dynamic factors that provide more insight into the individual and other reasons that they may fail to appear. There's been no research that examines factors of both failure to appear and non-failure to appear to see how they differ. And additionally, cluster analysis has not been applied to this topic in particular. So this was exploratory research, the aim being to develop profiles of defendant characteristics of who's most likely to fail to appear and those who are not. The data came from a nationally representative sample of individuals being held in jail for pretrial detention, awaiting a transfer, or were convicted and serving a sentence of a year or less. While this is an older data set, it was the only one that captured failure to appear as well as the static and dynamic defendant characteristics. So the dependent variable was self-report of whether they failed to appear to a court appearance or not. The data set was later split for the creation of profiles of failure to appear and non-failure to appear. A number of exploratory variables were used, and they were a combination of both static variables that have been previously included in failure to appear research, such as race and gender, and dynamic variables, which are more important in targeting the needs of those who fail to appear, including substance dependence. So here's a breakdown of some of the more distinct variables among the descriptives for failure to appear and non-failure to appear. I've highlighted some to note, such as sex. As you can see, there's a higher number of females who failed to appear. Marital status is relatively close between the two groups, but non-failure to appear is higher, so there are more married among non-failure to appear. And then there are higher rates of both substance dependence and stimulant use among those who fail to appear. So I used a cluster analysis is able to measure similarities and dissimilarities in a group and cluster them as such. So I used a two-step cluster analysis to create the typologies or the profiles. So it starts with a hierarchical cluster, which analyzes the distance between cases. This produces a guideline of how many clusters there should be, which then provides an approximate cluster number for the k-means cluster, which is sort of a profile ID process because it divides the cases into a required number of clusters and relocates the cases until they are closest to the center of each. Once the cluster groups were determined, a crosstabs was used to identify how the variables were spread across clusters, and a one-way ANOVA-Bonferroni test identified which clusters were significantly different from others across the variables. So for the sake of time, I'm going to have to be rather brief with these cluster profile results, but I'm going to highlight some of the more distinct ones. So cluster 1 were the prosocial cocaine users. There was high rates of chemical dependence as well as cocaine use. Failure to appear cluster 3 were a bit younger than other clusters, often in on property crime offenses, had a juvenile criminal history. And then failure to appear cluster 4 were the dual diagnosis females. They were the highest % female of the failure to appear clusters. They often experienced physical or sexual abuse, had high mental health diagnosis, as well as substance dependence. And looking at the non-failure to appear profiles, cluster 2 were the socially integrated with mental health issues. They often had social ties and a limited criminal history, but they do have substance abuse. Cluster 4 was the highest percentage female of the non-failure to appear profiles, and they often had a criminal history and regular drug use. And then non-failure to appear cluster 7, they often had low educational status and employment rates. Their parents had served time. They often had chemical dependence and a juvenile criminal history. This was also the youngest of all the clusters. So looking at failure to appear versus non-failure to appear across the clusters, a Bonferroni was conducted on a combined data set of all the clusters. It indicated which clusters were significantly different from one another. While there were clusters significantly different on many levels, failure to appear clusters 1, 3, and 4 were the most significant. Failure to appear cluster 1 had high rates of substance dependence, stimulant use, high rates of having served time in jail and prison, as well as a juvenile conviction. Failure to appear cluster 3 had high rates of property crime and a juvenile criminal history, while cluster 4 were the females having previously served time in jail and having juvenile convictions. I do want to point out non-failure to appear cluster 7. What's significant about this cluster is they differ from the other non-failure to appear clusters on many levels, yet they did show up for their court cases. So the creation of profiles through the cluster analysis did successfully allow for comparisons across the clusters, which indicated certain factors in which failure to appear differed from non-failure to appear. So property crime was an indicator of failure to appear, while public order crime was more prevalent among the non-failure to appear profiles. Criminal history and juvenile history were indicative of failure to appear, especially on these levels. What sets us apart from previous literature is that substance dependence was indicative of failure to appear. Specifically, stimulant use was more prevalent. Not everyone arrested for drug crimes have chemical dependency, so these may be more direct factors that may be better indicators than a drug offense, for example. Finally, females were more prevalent in the failure to appear, particularly failure to appear cluster 4. This cluster differed from many others, such as having co-occurring disorders, higher rates of physical or sexual abuse, and having partners who had served time, which may have been a result of the high percent female of that cluster. So the most indicative clusters of failure to appear were failure to appear cluster 1 and cluster 3. This was evident on the variables of property crime, drug use, and criminal history, including juvenile criminal history. Once again, I do want to point out non-failure to appear cluster 7, because it was significantly different from the other non-failure to appear clusters. But what's interesting is that they still did come to their court date, which could have been due to a number of factors, including being on some sort of conditional release, or they have a parent who made them go, or something about them is inherently different than those who failed to appear. So there were a number of limitations, which I'm happy to talk about, but for the interest of time, I will say that the main limitation that I want to acknowledge is the difficulty of measuring failure to appear. There's no definition of what constitutes failure to appear for this data set. It's simply a self-report of whether they failed to appear to court or not. Looking at the implications of this, pretrial risk assessments base a portion of the information on whether or not the individual has a history of probation violations or revocations. However, the findings here indicate that this might not be as indicative of failure to appear as previously thought. It may be more useful to incorporate more distinct or telling indicators such as criminal history, property crime offenses, or substance dependence. With this, having a pretrial assessment of substance dependence and incorporating pretrial conditions for those who are chemically dependent may be more useful in reducing failure to appear. Research could indicate what notifications may be useful in targeting, for example, property crime offenders or those with an extensive juvenile criminal history. As these groups are typically younger, they may be assisted by text message notifications or including a sanction in the notification. Next steps would be to test the predictability of the typologies through a regression and to look at data on a more local level in terms of notifications and definitions of failure to appear. So overall, this study provides more information on how those who fail to appear to their court appearance are inherently different from those who don't. By knowing and being able to address these factors, we are better able to provide targeted programs and practices to the needs of those individuals and hopefully improve attendance. So thank you for listening. I have my email here if you had any other questions you wanted to follow up on.
Thank you so much. There's a question for you. You can take a look, and then at the end, when everybody's presented, we can open up for a Q&A.
Sounds good. So at the very end?
Yes, that would be perfect. Thank you so much.
Thank you.
Awesome. Stacie, would you like to go next?
Yeah, of course. Let me just get my slides up. Can you hear me okay?
Perfect. Yes.
Yeah. Okay,
Thank
cool.
you.
Just give me 1 second. Now, I tested this yesterday with the presenter view. So if you guys could just let me know, is it the slides that you're seeing or the presenter view? Just want to double check.
Slides. Yeah.
Slides?
I get that problem when you have two screens. Yeah.
I know, exactly. Okay, perfect. So let's dive in. So yeah, my name is Stacie St. Louis. I'm a 5th-year PhD candidate at Northeastern University, and today I'm going to discuss one of the papers that's going to come out of my dissertation. So for this study, I had 2 key objectives here. The first was to understand the court system as a holistic process where earlier decisions impact later outcomes. I do this under the cumulative disadvantage framework, which is defined as a process by which prior negative events amplify the chance that future negative events will occur. You know, we call it a criminal justice system, case processing, a court system, and so I think it should be analyzed as such. And then my next goal was to understand the role of dangerousness in pretrial decisions and how that danger label impacts subsequent case outcomes. We know that pretrial detention serves 2 important purposes, protecting crime victims and the general public, typically via bail denial of the more dangerous offenders, and then also ensuring that a defendant will appear for their future court proceedings by typically assigning a high bail amount, and the threat of losing this amount encourages their attendance. But these are 2 very different groups of jail detainees, of pretrial detainees, and I believe they should be analyzed as such. Now, what does the prior research say? I know this is a text-heavy slide, so I'll just sum it up. Studies have consistently found that defendants detained face more severe outcomes than released defendants. This relationship holds across many states, even many countries. And the citations on the slide are only few of dozens that highlight that relationship between pretrial detention, conviction, guilty pleas, dismissals, charge reductions, incarceration, sentence length. And while there are, of course, some exceptions, particularly related to sentence length, there is overwhelming evidence, like the quote says, that pretrial decisions determine mostly everything. And honestly, that they have for decades. Pretrial detention can also exacerbate disparity related to race, gender, age, and adjudication and sentencing outcomes, both via direct and indirect effects. And while these are super important findings that expand our understanding of that domino effect in the criminal justice system, from my search, I did not see a study that really disentangled that pretrial detention type. But like I said, it's a crucial distinction here. Not everyone held in jail is considered dangerous. Many, in fact, most, the overwhelming majority, simply can't afford their release. So with that, my research seeks to examine that relationship between pretrial detention status and cumulative disadvantage, and how people denied bail, held on bail, and released may experience differential levels of cumulative disadvantage. Now, I hypothesize that controlling for defendant demographics and legally relevant factors, that detained defendants overall compared to released defendants will experience worser outcomes, being more likely to be convicted, less likely to receive a charge reduction, more likely to be incarcerated, and longer sentences. This is in line with that prior research I discussed. But I do not anticipate any substantial differences between defendants denied bail and held on bail. Again, despite them being very different groups, court actors may disregard these differences, applying that danger label to all. Court actors may also not even know the reason that somebody was detained pre-trial. And so this is something I seek to investigate further. Now to do this, I use the Bureau of Justice Statistics State Court Processing Statistics. This tracked felony cases across 9 waves from 1990 to 2009, and the sampling frame included the 75 most populous counties in the United States, which they then took a 2-stage stratified sample from. Now you can see that there's a lot of variables they collected on the right-hand side of the screen that fall into those 8 overarching categories. I will say they focus a lot on legal variables, not as many extra legal variables captured there, But nonetheless, the data spans 75 counties, 19 years, over 100,000 defendants. So it's a really unique and large-scale opportunity to follow defendants as they progress through our court system. Now, of those 100 or so measures, these on the slide were selected for the analysis, very much in line with that prior research I mentioned. You can see there's the 4 case processing outcomes that I'll be assessing on the left. Then we have defendant demographics and those legally relevant variables. Now you may be saying, oh my gosh, what about income, like socioeconomic status? We know that that's so linked to bail and pretrial detention. Unfortunately, as I was saying, the data set doesn't capture this. However, I do use attorney type as a proxy for measuring income. It's been used in a lot of prior studies on this, like SPAWN 2009 and plenty of others. And so I do use public defender, assigned attorney, as a signal for socioeconomic background, access to financial resources. Now with those variables, I conduct my analysis in 3 steps. So the first is that I created this really cool flowchart. It's a supplemental slide that we can look at during questions because I won't have time to go over it. But basically I go through each case processing stage and I say the percentage of detained defendants or people denied bail that were convicted, that received a charge reduction, the people that were released that received a charge reduction. And I assess the chi-squared and ANOVAs to see if those are significant differences, which they are. Next, using that, I move into a multivariate regression analyses, 4 models here for each of those dependent variables. And all of them, I include year fixed effects for each of the 9 waves. They're all multi-level to account for those clustering of cases into the counties. I use multiple imputation to address missing data, and then I also use case weights that are available in the data that were discussed on the previous slide. This will be my focus, the presentation on today, the findings section. And then what I'm next steps is, it's actually running in the background on my computer right now, is I'm also conducting a multi-level path analysis using these data. It's a really, really cool new and advanced method for analyzing cumulative disadvantage. Kurlichek and Johnson wrote about this in 2019 in their overview of cumulative disadvantage literature. And so I look forward to seeing if the results stand using that more sophisticated model. Anyway, presenting the results of the multivariate regression models, you can see here that the released defendants served as the reference group, and that across the board, people detained, no matter what the reason are more likely to be convicted, again, less likely to be incarcerated or receive a charge reduction, more likely to be incarcerated, and they receive longer sentences, very much in line with what I was predicting. What's also interesting though, when you look at charge reduction, it partially mediates that relationship between pretrial detention status and sentence length, and also pretrial detention and incarceration. Now, I will say these are all very significant differences, and that holds no matter what group you use as the reference group. If held on bail is the reference group, denied bail is the reference group, but the N on the data set is so huge that this is kind of inevitable. So I think it's really important to look into those more precise effect sizes and analyze their magnitude. So we can see here that pretrial detention status on conviction is pretty much the same whether or not you're denied bail or held on bail. The odds are about 100% or 110% higher to be convicted if you're held in pretrial detention as opposed to being released. Now, when we look at charge reduction, what's pretty interesting here is that, again, compared to released defendants, people denied bail have about 55% lower odds of receiving a charge reduction, and people held in bail about 40% lower odds. So there does seem to be that about 15% difference there, some interesting difference between denied bail and held on bail. Moving into incarceration, detained defendants have about triple the odds of being incarcerated than released defendants. And there's again that notable difference there. For people denied bail, the odds of being incarcerated are about 250% higher. And for people held on bail, I flipped that. The odds of being incarcerated for people held on bail are about 250% higher, and the odds of being denied bail, little about 210% higher. So again, we see that slight difference there between the 2 groups. And then finally, defendants detained pretrial, of course, receive longer sentences as well. These are B coefficients stemming from the log transformed dependent variable of sentence length. So more substantively, people denied bail receive about 95% longer sentences than those released. and people held on bail about 55% longer sentences than those released, meaning that people held denied on bail do receive those much longer sentences, even when controlling for things like committing a murder or having a more violent offense, having more prior felony convictions. So it is really interesting here. We are seeing a slight difference in effect between people denied bail and held on bail, but overall, that being detained is just not a situation to be in. It leads to cumulative disadvantage across the board. So just my last slide. Why are we finding these results? Some things I speculate, some are held in prior literature. People held in pretrial detention are viewed as dangerous in subsequent case decisions. That's that danger label, even if they're only detained because of their income level, because they can't afford that median bail of $2,000 that's in the data set I am using. Pretrial detention can impact your ability to prepare your defense, including meeting with your attorney. There's this really interesting article called like Hell is Trying to Visit My Jail Client. And the attorney by Boucher, I believe 2017, goes over all the ways that's really difficult to meet with your clients that are incarcerated. Also, loss of employment for people that are already struggling with money, paying an attorney, paying their bail. So with that, I have two key recommendations here. First is just to decrease the overall number of people held in pretrial detention, and we can do that by assigning a bail relative to somebody's financial status. If you assign a bail without considering this, what's high to one person may be low to another, and vice versa. Then people can be released based on their income level. So if you assign a bail to someone that's just unimaginably high, that they could never afford it, you're basically denying their bail. So that's something cool to keep in mind that the Massachusetts Supreme Court just ruled on. And then my other recommendation is minimizing the burdens of pretrial detention for those that are ultimately detained. More visiting-based technology, less fees for phone calls, easier time meeting with attorneys, perhaps even a work release program so they can maintain their job. Now, as we talked about in the previous presentation, the federal government spends billions of dollars to incarcerate pretrial populations every year. My estimate based on BJS data is that touches the lives of approximately 7 million people every year, and that's 1 in 37 Americans when comparing it to the adult population. So this is a really big issue that really needs to be explored further. So with that, thank you for your time. Email address is also on the slide, and happy to answer any questions. I also have a lot of supplemental slides that we can dive into during the Q&A.
Thank you so much. That was awesome. All right, next group up. Evan and Eric. Spencer, awesome.
Hello, everyone. Let me bring up my presentation. All right, so hello, everyone. Thank you for joining. My name is Spencer Lawson. I'm a third-year doctoral student in the School of Criminal Justice at Michigan State University. So this presentation is going to report out on results on the predictive accuracy of a pretrial risk assessment by race. So just though, as a quick disclaimer, this research team received support for this project by the Indiana Office of Court Services. So the views and opinions expressed are all ours and do not necessarily reflect the views and opinions of IOCS. So Indiana is part of this growing national movement for pretrial and bail reform efforts with the Indiana Risk Assessment System, pretrial assessment tool, or the IRAS-PAT being at the center of these efforts. And so part of this Indiana pretrial initiative, Indiana selected 11 counties to pilot the IRAS-PAT assessment. And those participating counties are on the screen right now. So the research team involved in this initiative aimed to answer the question of, does the IRAS-PAT predict pretrial misconduct? Or in other words, does it actually do its job? So to really answer this question, we provided county level validation of the IRAS-PAT assessment. And I just want to stop here briefly and really emphasize that this is what is unique to our study. So given that a lot of these counties were granted flexibility to tailor program implementation and pretrial service operations based off the needs of their community. We had to develop and spend a lot of time developing protocols that balanced both county level practices with strict inclusion criteria to model this prototypical case processing. So I've mentioned now like a lot about the IRAS-PAT, but specifically, like, what am I talking about? So on this slide, you're going to see the instrument. It is or at least a high level overview of the instrument. So it's a 7-item tool that was developed specifically to assess risk of any arrest, risk of any new arrests, and then any failure to appear, or FTA, in pretrial defendants. And then the items broadly assessed 4 criminogenic risk domains. So some of them touched upon criminal history, while others hit upon employment, residential stability, and substance use. So regarding the scoring, defendants can receive a total possible score ranging from 0 to 9. And then from that, you can break up these total scores into 3 risk levels. So there's low risk, which would be a score of 0 to 2, moderate 3 to 5, and then high risk from 6 to 9. So the research team was involved in this pretrial initiative, and we were trying to answer the question of, does the IRAS-PAT do its job? So what did we find? Well, the IRAS-PAT assessments produce good to excellent levels of predictive accuracy across pretrial misconduct outcomes. And in fact, the IRAS-PAT predictive accuracy estimates mirrored or exceeded predictive accuracy produced from other pretrial risk assessment tools. So the research team found encouraging results when examining the IRAS-PAT. So the next question is kind of, where does this leave us? What are our next steps? Well, the impetus really behind the current study is a growing concern that there is bias when using risk assessments. And unfortunately, there are limited, but there are a growing number of investigations that really look into predictive bias of pretrial risk assessment tools, including the IRAS-PAT. So our research team looked into this. But what do I mean when I say predictive bias? And what I'm talking about is we wanted to examine whether assessments are stronger predictors of pretrial misconduct outcomes for white defendants relative to Black defendants. And when there is bias, though, this bias is typically found at higher risk levels. So where Black defendants tend to be overclassified relative to the risk of misconduct. So transitioning into the current study, and to really investigate this predictive bias within the IRAS-PAT, we used a multi-jurisdictional pooled data set from 5 of the Indiana pilot counties that participated in that Indiana pretrial initiative. So the sample was comprised of about 700 Black defendants and 2,800 white defendants. And just more on a technical note, we conducted propensity score matching on a variety of different demographics and case characteristics. So we conducted both weighted and unweighted analyses to address criticism, and that criticism being that evidence of predictive bias within an assessment is actually attributable to differences in baseline characteristics between groups and not really focused on the domains being assessed. So our propensity score matching was an attempt to address that criticism. So the pretrial outcomes we were interested in were any FTA, any new arrest, and any arrest. And just for sake of time, I'm only going to present out on the IRAS-PAT risk level as the main independent variable in some of my multivariable models. So jumping into the results. So here is a graph of risk level distributions overall and by race. So for the overall sample, meaning that we just pool the data across all 5 counties, 43% of defendants were classified as low risk, with fewer defendants being classified as high risk. And then on average, Black and white defendants had similar rates of risk levels. Next, so here is a slide that looks at the proportion of defendants with misconduct at each risk level by race. And as you can see, rates of pretrial outcomes are higher for Black defendants assessed at low risk relative to white defendants. And then rates are similar between white and Black defendants assessed at moderate risk. At high risk, however, as you can see now with the boxes being outlined in red, Black defendants have lower rates of all outcomes relative to white defendants, particularly for this any FTA and any arrest outcomes. So in other words, we're not seeing a similar incremental gain in proportion of misconduct as we move from low risk to high for Black defendants. So jumping into some of the predictive accuracy results. So here's a table of area under the curve, or AUC, statistics for total scores and their associated conventions separated out by race and outcomes. And for researchers that study risk assessment, AUCs are the gold standard. And just AUC values can range from 0.5 to 1, with 0.5 indicating predictive accuracy at chance levels, and 1 indicating that perfect prediction of outcomes. And as you can see, the IRAS-PAT assessments produced weaker predictive accuracy estimates overall for Black defendants relative to white defendants. And so here are some multivariable models of IRAS-PAT risk levels and race predicting those 3 pretrial misconduct outcomes. I recognize there's a lot of information on the screen, but I really want to bring your attention to the interaction terms. So as you can see there are 2 significant interaction terms, one in the any FTA model and then one in the any arrest model. So to really kind of to visualize these interactions, we decompose them and present predictive probabilities and their associated 95% confidence intervals. And what we're seeing is that Black defendants classified at high risk have lower predictive values of any FTA and any arrest relative to white defendants. So what does this all mean? So I presented some bivariable comparisons, AUC estimates, multivariable models, all looking at how IRAS-PAT functions across race. Well, together it means that there is evidence of lower predictive accuracy and overclassification for Black defendants at high risk, particularly for FTA risk and risk of any arrest. However, importantly, these results really don't inform why the IRAS-PAT assessments may be producing different levels of predictive accuracy, including whether specific items within the assessment, whether those items could be driving these trends. So our research team, we are looking into this. Just for sake of time, we really couldn't get into it. Also, these findings really don't speak to how these assessments may have been used in practice to facilitate the release of pretrial defendants, reduce or eliminate bail bonds, or decrease the amount of time in pretrial detention. The research team has looked into this in an NIJ study, and the findings, well, despite evidence of predictive bias in the IRAS-PAT assessments, the structured decision-making associated with the IRAS-PAT implementation in the pilot counties appeared to improve pretrial outcomes for both Black and white defendants. So that could be such as like increases in rates of release, similar decreases in bond amounts, and length of pretrial detention for both Black and white defendants. So thank you all for your time. If you have additional questions about the Indiana Pretrial Initiative and the studies, I encourage you to reach out to the PI of this project, Dr. Evan Lowder with George Mason University. So with that, I yield my time. Thank you so much.
Thank you so much. That was awesome. There are several questions in the chat, so please feel free to get to them. Let's see. I think the first one is for Ciara, and then I think Stacie. So there's plenty.
Yeah, I can start with the first question really quick. Sorry, I'm reading it right now. I have not seen that. It's on the Pretrial Justice Institute website. I think that's really interesting, and I definitely want to consider it. So thank you for pointing that out. But yeah, I have not seen that yet.
Okay, I think I have a few questions, so I'll just go through them in the order, I think, that they were posted. So first from Jacqueline, You mentioned pretrial risk assessments, and I thought that this was a really interesting question because I read this article by Golden in 2016 that discusses kind of what exactly I'm talking about here, disentangling flight risk from dangerousness, and she discusses risk assessments at length. The idea that she presents that I think is pretty intriguing, that risk assessments currently like lump these together. And that's a major issue because then you can overestimate risk. I think at least at the time she wrote it, only one pretrial risk assessment, I believe it was from Arnold Foundation, had disentangled flight risk from dangerousness. And it's really interesting though, because some things predict dangerousness, predict reoffending, and then other things predict flight risk, right? Other things predict, whether or not somebody will appear for court. And then other factors don't predict both. So it is important to separate these because otherwise we might overestimate risk here. And we have pretty effective ways of monitoring people in the community, with technological advances, electronic monitoring. So this is something that we could look into further. I hope I addressed that pretty well. Ciara, you raised a really cool question. This is initially what I actually wanted to do for my dissertation. I'm very, very interested in how being detained pretrial can have collateral consequences for the offender and their families, particularly on their employment, their housing, their relationships, healthcare, for them and their loved ones. This is something that I've seen happen firsthand, where people lost their apartments, lost their jobs, even faced deportation. And it's been really eye-opening and something I definitely look forward to investigating further. And the author of that report, Jacqueline, is Golden. I think her name is Lori Golden. It's Gouldin. It's super interesting article. I definitely recommend reading it. The next question down was from Evan, and this is a really interesting question, Evan. I was actually looking back through the data to see if they provided more specifics on this, but unfortunately, from what I can tell, they don't really classify how they defined detained versus released, and that's a huge problem, right? Because I think that future research needs to be more clear about this. When you're assessing pretrial detention, is it, that initial decision that's made? Is it whether or not they're detained pretrial when they're ultimately facing that conviction? Is it the number of days that they're held in pretrial detention that leads to those more severe effects on their case processing outcomes? It's going to be something I look into more with these data because I do want to present this more clearly in my paper. And so I thank you for bringing that up because it is something that I slightly overlooked, but I also know is very important to define. And then I think that is everything. If I missed a question, I apologize, but I'll hand it over now to Evan.
Yeah, so I can jump in real quick. Jacqueline had a question as well. And I think Jacqueline, so just to sum up Jacqueline's question, it was about some revisions to these risk assessments and specifically changing maybe some of the language to be more strength-based. So I think that's going to be part of a lot of different conversations when you start seeing some of these disparities in predictive accuracies. And this predictive bias element within risk assessments is, what are we doing? What's the next step? And revising some of these tools, whether that could include adjusting some of the scoring of individual items, removal or addition of items, or really just recalibrating these tools to meet the needs of their communities and to address these disparities are going to be part of kind of a growing and larger dialogue within the kind of the scholars and practitioners that are using these tools to just essentially to address a lot of the criticism that's out there on them. So yeah, I think Jacqueline, you're touching upon kind of a next step that a lot of people are going to start. They're going to start having those conversations, and those conversations are already actually occurring. Definitely kind of at the local level is, you've found this finding, what do we do next? So our goal is to, definitely with the Indiana research team, is to continue to work with our partners, our local practitioners. They've been great working with all of them, understanding their pretrial processes and just the the desire to make sure that these risk assessments are equitable and are producing fair and just outcomes. So yeah, I think that's a great question, Jacqueline, and I think it's revisions are definitely going to be on the table to for future discussions.
Any other questions? Okay, great. Oh, cool. Oh, Frank had a question.
I think that he's referring, or I think that Eric was referring to Frank's question to me, perhaps, about what it could look like if we released more people into the community, because that is one thing I called for, of course. And I think I touched on this a little bit in my answer to another participant, and I apologize for not answering it a little bit more clearly. But like I said, I think that it's really essential to utilize electronic monitoring. I really liked Ciara, if I'm pronouncing that right. I know we spent a minute on that earlier. I apologize. But text message notifications are really interesting as well. I remember reading a study or perhaps watching a documentary that was saying that some people miss court just because they forget or because they can't get into the courtroom that day or they don't have a car or transportation to get there. And obviously that's not everyone, right? I mean, there's some people that very much intentionally miss court, but if we can help people and make it as easy as possible for them to come to court, and also having things like I said, text message notification, perhaps some kind of transportation, and having that electronic monitoring that we know is pretty effective as well. I think that these are all things that we could look to, and of course, future technology innovations as well.
Any other questions, comments? Let's see. Thank you so much, everyone. This was a great panel. This is a great opportunity for all of us to network. It has been awesome. Anybody have any more questions, any comments? Thank you so much to all the attendees. Thank you so much for all the panelists, for your presence here, for your contributions. Great job, everyone. I look forward to, hopefully meet you all one day. And in the meantime, enjoy any of the other panels you go to, and good luck with any of the other presentations that you have. Take care, everyone.
Thank you, everyone.